Hello friends, Jai Hind. Today we'll be discussing about reservation policy in India, the way it exists in India, and how does it differ from the other countries and the various pros and cons of reservation. Well, first of all, let's define what's reservation. It's termed as positive discrimination. It's an affirmative action for helping those who are discriminated against or those who have been left backward because of circumstances beyond their control. Now, what is positive discrimination and what is affirmative action? Let's take an example that there is a cricket match going on. There is a wall around that cricket match, no place to sit inside. Children are trying to watch that match from outside the wall. There are tall children and there are short children also, younger ones. The taller ones can see it over the wall. The younger ones are finding it difficult to see the match. So a positive discrimination or an affirmative action is taken. The younger ones are given benches or stools to raise their height so that they can easily watch the match. This is an example of positive discrimination. You see, unequals cannot be treated as equals. Similarly, equals cannot be treated as unequals. And those who have been left behind in the race have to be helped out. And the method of helping out is positive discrimination or affirmative action. An example of that is reservation. Now, reservation in the form that it exists, it not only exists in India, it exists in other parts of the world also. For example, in Norway, women have 40% reservation. In Canada, the Aborigines and the minorities have reservation. In Japan, the indigenous people and the tribals have reservation. But the Indian reservation is far too widespread and it's very different from the reservation of other countries. Indian reservation is not minority based. Means the minorities don't have any reservation. The Indian reservation system is caste based. As we are all aware, the scheduled castes have got 15% reservation. The scheduled tribes have got 7.5% reservation in jobs and educational institutions. The other backward classes have got 27% reservation. Persons with disability have got 5% reservation. And the latest addition is the economically weaker sections of the unreserved class, they've got 10% reservation. So if you total all these, I think it amounts to around 64%, and it far exceeds the 50% cap given by the Supreme Court. Now, the scheduled castes are there in the Hindu religion and certain offshoots of Hindu religion like the Sikhs and the Buddhists. The Sikhs and Buddhists also have got scheduled castes. The Muslims and Christians don't have any scheduled castes. What about the OBC? All religions have OBCs. The Muslims and Christians also have OBCs, and a large number of Muslims and Christian classes or small little communities have been included into the OBC list of the center and the state after the Mandal Commission. Now, the scheduled tribes. The scheduled tribe reservation is religion neutral. By religion neutral, what we mean is that people living in difficult geographical areas, in inaccessible areas, having tribal cultures are given reservation, irrespective of their religion. For example, the Nagas of the northeastern hills, they come under the scheduled tribe, Naga tribes. They are Christians. The Gujar Muslims of J&K, they are a scheduled tribe, they are Muslims. So it is religion neutral. Hindus, Sikhs, Buddhists, Christians, Muslims or any other religion living in geographical inaccessible tribal areas are given the ST status. Let's go a little down and we'll read the history of reservation in India. See, reservation is not a new phenomenon. In 1882, William Hunter and Jyotiba Phule, they had proposed caste-based census in India. So the story started from there. In 1932, the Prime Minister of Britain, Prime Minister Ramsay MacDonald, he pronounced the communal award. and many of us are aware about the communal award. The communal award was a demand of people like Ambedkar. Communal award meant separate electorate for the Muslims, the Sikhs, the Anglo-Indians, the Christians, the Europeans and the Dalits. Separate electorate for them. Ambedkar was very much in favor of separate electorate for the Dalits and had campaigned for it. Somehow Mahatma Gandhi was deadly against it. Mahatma Gandhi that time was in Yerwada jail, Pune, and he started his fast unto death to bring Ambedkar to some reconciliation. Gradually, as Mahatma's health started deteriorating, Ambedkar came under pressure. Ambedkar goes to Mahatma Gandhi in the Puna's Yerwada jail, and the famous Pune Pact was signed. In that pact, Ambedkar agreed on a single Hindu electorate with some inbuilt reservation for the SC/ST, no separate electorate for the SC/ST. This is all about the Pune Pact. We go a little down. Let's read something about the opinion of the constitution makers. Well, there are certain myths about reservation, when it started, how it started. The original Constitution of India, when it was enacted in 1950, reservation was only for the legislature. There was quota for legislative seats. And initially it was introduced only for 10 years, that is till 1960, as per Article 334. Somehow, for political reasons or for vote bank reasons, subsequent amendments were carried out by the legislature and the constitution was amended, extended, the reservation was extended for quota in legislatures, and it is continuing still. So initially when the constitution was enacted or came into force in 1950, the reservation was only for the legislature, and that too only for a period of 10 years, but however revised and extended subsequently. Provisions of reservation for in educational institutions and government jobs came in the year 1951, 1 year after the constitution was enacted or came into force. And Article 15.4 and 16.4 15.4 was inserted into the constitution. So reservation for jobs and educational institutions came in 1951. However, reservation for within the legislature was there since the beginning of the constitution. Now let's clear this. We go a little down. Very interestingly, no time period was given for the validity of reservation mentioned in Article 15.4 and 16.4. The reservation for jobs and educational institutions, large number of people have got confusion that it was only for 10 years. No time period was specified. And the initial reservation were only for SC and ST as per Article 15.4 and 16.4. That point in time, OBC question didn't exist. The OBC reservation came in pretty late in 1991 as per Article 15.5 of the Constitution. That is after the Mandal Commission and the mayhem that followed Mandal Commission. The reservation for the economically weaker sections of society, EWS, 10% reservation for EWS, is a very recent phenomenon. It came in the year 2019. And Article 15.6 and 16.6 subsections of 15.6 and 16.6 talk about EWS reservation, 10% reservation for the economically weaker sections of the unreserved group, the unreserved section of society, the so-called Savarn or the upper caste. Now it is needless to assert here that as per the spirit of the Constitution, the constitutional founding fathers of our Constitution never intended the reservation to continue for eternity, but somehow it's still perpetuating. And to further emphasize, initially it was only for the Hindu religion. In 1956, Dalits of Sikh religion, convertees into Sikh religion, were also included. And 1993, the Buddhists of Sikh, the Dalits of Buddhism also were included in the SC category. Other religions don't have SC category, only Hindus, Sikhs and Buddhists have. Now let's clear this. We go a little down and we study about the Mandal Commission, a very important landmark in the history of India's reservation. The Mandal Commission of 1990. Actually, the Mandal Commission was formed as per directions of the then President under Article 340 of the Constitution, and it was constituted in the year 1978. It was the second backward class commission. The actual name was Second Backward Class Commission, and it was constituted during Prime Minister Morarji Desai's government. Now, since this was headed by Bihar politician Sri B.P. Mandal, it famously came to, or popularly came to be known as Mandal Commission. The actual name was Second Backward Class Commission. And what was the task given to Mandal Commission? The task given was to determine the criteria for backward classes and suggest measures to improve their condition. The Mandal Commission worked hard and it gave 11 different indicators of backwardness that included the economic criteria, the educational, the social and other criteria. But somehow the Mandal Commission made a major mistake. That's what the people say, the critics say. We'll just discuss what mistake the Mandal Commission made. Let's go down. As we have discussed, 11 indicators were given by the Mandal Commission. The Mandal Commission wrongly based its calculation of the strength of OBCs on 1931 census, a very old census. Well, calculating the OBC strength based on 1931 census in the 1990s, early 90s, is quite a folly. And more so because before 1990, there was never ever a caste census. They based on the general census of 1931. And they wrongly calculated that 52% of the population, other than SC and STs, are OBCs in India, thereby directly or indirectly suggesting that more than half of India is OBC, which was not a fact. The subsequent facts prove that the OBC population in India is somewhere between 32 to 36% approximately. The Mandal Commission listed the backward classes and gave a list of 3,743 OBC castes, gave a list of 2,108 depressed backward class, Ati Pichhada Varg. The Mandal Commission further recommended 27% reservation for the other backward classes, OBCs. They also recommended a reservation for the economically weaker sections. However, the report of the Mandal Commission was deliberately, to some extent, never implemented. The then Janata Dal government didn't implement it. Thereafter came the Congress and the Mrs. Indira Gandhi and Rajiv. They also deliberately slept over it for almost 10 years, to the extent that Prime Minister Rajiv Gandhi even called it a can of worms. So nobody wanted to touch it, and it was put on the back burner for almost 10 years. Then what happened during Rajiv's government was the Bofors scandal happened. The then Defence Minister, Mr. V.P. Singh, stood against Rajiv Gandhi, criticizing him for the Bofors scandal. It became a campaign. Rajiv Gandhi's government fell, and a coalition government under V.P. Singh, the National Front government, was made. Now what happened was, now V.P. Singh was a minority government. There were other people also eyeing for Prime Minister's posts, such as Tau Devilal and Chandrasekhar. Mr. V.P. Singh wanted to leave a legacy. He knew that he is not going to stay very long, and to bring in permanence in his tenure or to seek public applause, he thought of bringing back to light the Mandal Commission of 1987. Let's see what happens further. If you go down, Prime Minister VP Singh decides to bring Mandal Commission to light in August 1990. Now, Tau Devilal, the Jat leader of Haryana, and Chandrasekhar, they were also eyeing for Prime Minister post, and they were just waiting for an opportunity to dislodge VP Singh. To bring himself to prominence and to subdue the efforts of Devilal and Chandrasekhar, VP Singh played the card of bringing forth the Mandal Commission report and implementing it. As we are aware, Mandal said 52% population other than SC, ST, OBC, because they erroneously based their data on 1931 section. Mandal asked for 27% reservation for the OBCs, that is, at least, that was basically because by then the Supreme Court had already capped the reservation at 50%. So, beyond 27% they couldn't have asked, it would have exceeded the 50% mark. So they said, give us 27%. They gave a list of castes of OBC and depressed classes. The OBCs also included Hindus, Sikhs, Buddhists, Muslims and Christians too. This is an important point here. Muslims and Christians too were included in the OBC list. And you see, the moment on 15th August 1990, when from the ramparts of Red Fort, Prime Minister VP Singh announced the implementation of Mandal Commission, there was mayhem on the street, hue and cry all around, and India saw one of the worst protests in the history of India. Large scale protests started. Delhi University, Allahabad University, Patna University became the epicenter of protests. There were protests from both sides, pro-Mandal and anti-Mandal also. And especially it was more pronounced in northern India, because northern India had a large OBC population. 159 self-immolation attempts were attempted by students, and sadly 63 of them succumbed to their injuries. One student of Delhi University, Sri Rajiv Goswami, his self-immolation pictures were all over newspapers. And the protests were far too widespread all over northern India and to some extent in other parts of India too. The mayhem was not tolerated by Mrs. Indra Sahni, a lawyer. She moved the Supreme Court. And that's how the famous Indra Sahni versus Union of India case came to light, and it's a landmark judgment on India's reservation system. Let's go down. Now here, VP Singh had edged a place for himself amongst the OBC. Large number of OBC leaders like VP Singh, Lalu Yadav, Mulayam Singh Yadav, Sarad Yadav, etc. emerged. BJP was in effects. BJP thought that now VP Singh and his National Front would perpetuate into power. In order to dislodge VP Singh, or to divert attention from the Mandal's success, BJP tried to shift focus from Mandal to Mandir. What was the Mandir? It was construction of Ram Mandir in Ayodhya. The old man, that time not so old, Mr. L.K. Advani, started the Rath Yatra from Somnath to Ayodhya between 30th September to 30th October 1990. Aim being mobilize the sentiments of the masses in favor of the Mandir and gain popularity for BJP. The Yatra was a huge success and attracted huge crowds. VP Singh was clear. VP Singh said that my love and kush, his love kush were Lalu and Mulayam Yadav. They would be able to stop the Ram Rath of Sri Advani before it enters Ayodhya. He wanted to give it a historical semblance to the Ram Aswamedh Yagya horse being stopped by Love-Kush. Advani managed to pass through UP. However, he was arrested in Samastipur, Bihar by none less than Sri Lalu Prasad Yadav. Now the VP Singh's government was with BJP support. BJP withdrew support. VP Singh government fell. And Mr. Chandrasekhar was eyeing the Prime Minister's post, went to Congress, asked for Congress support and formed the government. He stayed for almost 6 months. And again, as usual with the Congress withdrew support. Let's go down further. Now the Indira Sawhney versus the Union of India case was already in the court of law. It was filed in 1990 and continued hearings till 1992. The Honorable Supreme Court examined the scope and extent of Article 15(4) and ruled the following. Very important. This will be important from your examination point of view. The Honorable Supreme Court ruled that social and educational backwardness be the only basis for backwardness. Economic status can't be a basis for backwardness. Very clearly iterated by the Honorable Supreme Court. Further, the Honorable Court asserted that there will be 50% cap on caste-based reservations. No caste-based reservation beyond 50% is permissible. The Honorable Supreme Court agreed the Mandal Commission's recommendations of 27% OBC reservation. They said it's okay, acceptable. However, the 10% reservation which was proposed for EWS by Mandal was rejected and considered invalid. Further, the Honorable Court said reservation is only meant for initial employment and not in promotion, not even in promotion for the SC/ST. So we repeat, the Indira Sawhney judgment was basically to examine the scope and extent of Article 15(4). Only social and educational backwardness will be the criteria for backwardness, and economic status cannot be the criteria for backwardness. 50% cap on caste-based reservation, 20% reservation for OBC was held valid, 10% reservation for EWS was rejected, and reservation was permitted only in initial employment, not in promotion. Now let's go further. What happens hereafter? Indira Sawhney case very clearly capped the reservation at 50%, but still large number of Indian states reached the 50% cap because reservation is a touchy issue and it's a vote harnessing issue, vote earning issue. Tamil Nadu has got 69% reservation. Now the question is, how does Tamil Nadu manage to get 69% reservation? Well, in the year 1993, Tamil Nadu Reservation Act 1993 was passed. Under the 76th Amendment to the Constitution, it was inserted into the 9th schedule of the Constitution and presidential assent was taken. Now, any act, if it is inserted into the 9th schedule, it becomes untouchable by the judiciary. However, subsequently we will discuss what happened. There are certain other states like Haryana, Chhattisgarh, Gujarat and Maharashtra, they have also exceeded the 50% cap. Now this Tamil Nadu case of 69% reservation is still sub judice in the Honorable Court. How? Let's see. In 1981, the Baman Rao versus Union of India case decision was given by the Honorable Supreme Court. The Honorable Supreme Court ruled that judicial review is possible for 9th schedule subjects to, if added after case Swanand Bharti decision of 1973. Gentlemen, we are all aware that the 1973 Kesavanand Bharti decision, the Honorable Court had said, there is something known as the basic structure of the Constitution and the Parliament doesn't have power to alter the basic structure of the Constitution. Now, in case anything has been inserted into the 9th schedule after 1973, it can be reviewed and shelved by the Supreme Court. And the Tamil Nadu Reservation Act was 1993. So, the Supreme Court is still considering it. It may, at a subsequent, accept or reject it. That's a course to be seen in the future. But this was just basically to inform you that 1981 Bamana versus Union of India case, anything in the 9th schedule is also subject to judicial review if it has been inserted into the 9th schedule after 1973. Anything before 1973 is untouchable, cannot be touched by or cannot be reviewed by the Honorable Supreme Court. Now let's see what happens further. Not only that, during Prime Minister Manmohan Singh's government also certain measures were adopted to harness more and more votes. I mean, every political party does it. There is nothing wrong, or there is nothing different that Manmohan Singh did. In 2004, Justice Rangnath Mishra Commission was formed, and it published a report in 2007, and it was tabled in the Parliament in 2009. It was during Prime Minister Manmohan Singh's Congress government. What did Justice Rangnath Commission say? Justice Rangnath Mishra Commission recommended that the SC status be delinked from religion. Means as of now, only Hindus, Sikhs and Buddhists have got SC status. All religions should be permitted to have SC status. The SC status should be made religion neutral like ST. Just as STs don't have any religion, they are geographical area specific. The SC status should also be delinked from the religion. The main aim was to bring certain sects of Muslims and Christians also into the SC status. However, due to insufficient data, it was never accepted by the Parliament. The second attempt by Prime Minister Manmohan Singh's Congress government to garner Muslim votes was in 2005, the Satchar Commission report. The Satchar Commission was constituted to study socio-economic conditions of Muslims. And the Satchar Commission clearly said that the conditions of Muslims didn't improve even after conversion. Those Hindus who converted to Islam, their conditions still didn't improve. The Satchar Commission recommended reservation for the minority, that's for the Muslims, I believe 4% or something. However, the Satchar Commission also never saw light of implementation. So this was just to inform you that in 2004 and 5 under the Congress government also there were attempts to woo the minorities. Now just see an interesting fact, how the BJP viewed the certain sections of BJP viewed the Satchar Commission report. The BJP, you know how the politicians change their goalposts. You know, a part of the BJP stalwart said the Satchar Commission cannot thrust its opinion on Pope and Maulvis. This would tend to formal induction of caste system in Christianity and Islam. This is beyond the purview of Parliament and Judiciary. This is contrary to the provisions of Holy Quran and Bible. You see, they suddenly remember the Holy Quran and Bible because it suits them. They can change goalposts the way they feel like. So when it comes to their own personal benefit, or when it suits their own political agenda or their own political thinking, they can always avoid reservation for the minorities by this kind of flowery language. And just for your information, I am neither for nor against reservation. Let's go further down. The latest addition into the reservation cauldron is the year 2019 under Prime Minister Narendra Modi. The 103rd amendment added to the constitution, and it gave 10% reservation to the economically weaker sections amongst the unreserved category. Which category? Unreserved category. The 103rd amendment introduced Article 16(6) into the constitution, giving 10% reservation in government jobs and educational institutions to economically backward in the unreserved category. You are all aware who all are economically backward in the unreserved category. I think less than 5 acres of land, they say, and certain certain specifications of plot in the municipal and non-municipal areas, and less than 8 lakh of income, and such like things are there. You can surf it on the net. Thus, the Article 103rd Amendment amended the Article 15 and 16 by addressing classes, empowering the government to, by adding classes and empowering the government to provide reservation on economic basis. Till now, till 1990, there was never a reservation based on economic basis. This is how the This is despite the decision of the Indra Shahni judgment. And this 10% reservation was over and above the 50% cap. Now let's see what happened further. Age is obvious in India and in any democracy for that matter. Large number of court cases were filed against the 103rd Amendment, that's the EWS reservation. Some 33 odd court cases were filed against the EWS reservation, the main being Janit Abhiyan versus the Union of India. This was the main case, and all were clubbed into one. The Janit Abhiyan argued that Article 103 violates the basic structure of the Constitution, and it gave three reasons to support its logic. What was the logic given by Janit Abhiyan to counter the EWS reservation? It said, economic basis for reservation undermines the original logic of reservation and it is inappropriate. Economy cannot be a basis for reservation, first they said. Second, they said it is discriminatory because it excludes the SC, ST and OBC. They said it is discriminatory in nature and it should include the SC, ST, OBC, so it is wrong. And thirdly, they said it breaches the 50% cap despite no special circumstances. The Indra Shahni case had clearly said that any reservation, caste-based reservation, cannot exceed 50% cap except in special circumstances. So here the Janit Abhiyan said there are no special circumstances. So they said economic basis wrong, it is discriminatory for SC, ST, OBC, it breaches the 50% cap despite no special circumstance. This is the logic they gave. The court kept hearing both the sides till November 2022. Now see what happens in November 2022, that is this month only. You all must be aware, but I will just repeat. In November 2022, a 5-judge bench of the Honorable Supreme Court upheld the validity of Article 103 by 3:2 majority. You see, there is a split judgment here. Although the majority is in favor, but 2 judges have dissented also. Now there is a decision by 3 judges in its favor. Who are the 3 judges? Justice Dinesh Maheshwari, Justice Bela M. Trivedi, the lady justice, and Justice J.B. Pardiwala. They all 3 gave decision in favor of the EWS reservation. They said EWS reservation is valid. It was upheld by a validity of Article 103 they upheld. These 3 judges said it doesn't alter the basic structure of the Constitution. They said it's not discriminatory against SC, ST and OBC because it doesn't eat into their quota. And they further said that the EWS reservation is over and above the 50% cap. They said EWS is a separate category and nowhere Constitution says that you can't grant reservation to a separate category. So this is basically playing with words, I think. I'm not trying to criticize the Honorable Supreme Court, but the court in its wisdom decided that it's a separate category and so the reservation is valid. Now, Indra Shahni decision says that 50% cap can be breached in special circumstances, and the 3 judges said these are the special circumstances existing now. These people have are economically pretty poor. However, the 5 judges, all 5 judges were unanimous and said that this EWS reservation will be applicable to private and unaided institutions also, as is any other reservation for that matter. They further said that the 50% cap was meant only for ST, SC and OBC reservation. This EWS reservation doesn't eat into the SC, ST, OBC quota. And finally they said adding an additional layer of, it's a layer of affirmation, it's another affirmative action. Adding an additional layer of affirmation doesn't amount to violation of basic structure of the Constitution. So the 3 judges, the majority rejected the petitions and they said it's a valid reservation, nothing wrong in it. However, there were 2 judges who had a contrarian view. What was the contrarian view of the 2 judges and who are the 2 judges? Let's see. The 2 judges were the then Chief Justice, now retired, Justice U. Lalit, and Justice Ravindra Bhatt held their contrarian view. And what did they say in their contrarian view? They said, yes, we accept that EWS reservation is correct, but it is wrong to exclude SC, ST and OBC from the ambit. the EWS reservation should also permit the SC, ST and OBC to participate in it. They further said that excluding SC, ST, OBC is against the basic structure of the constitution. Well, give EWS reservation but include SC, ST, OBC, that's what they said. A very interesting fact they brought out, Justice Bhatt specially. He said, India's total BPS strength is 31.7 crore. SC is 38%, ST is 48%, OBC is approximately 13 to 14%, and others are only approximately 5 to 6%. So if you total all these, it amounts to 90%. Keeping the others out, 90% of the India's BPL strength comprise of SC, ST and 95% rather, comprise of SC, ST, OBC. And excluding this 95 BPL people from economically weaker section category is against the basic structure. How can you just say that those who are below poverty line are not economically weaker? They can't take advantage of the EWS reservation. Very strong words and logical also to some extent. Let's go down further. Further, the two dissenting judges said, EWS reservation is a slippery slope and more states would ask for it. Rightly so. They further said right to equality shouldn't become the right to reservation. Everybody would start asking for reservation. The race to the bottom would start. Reservation is not a poverty elevation program. Very strong words. Further, Justice Bhatt said that the benefits accorded to ST, SC and OBC कोई खरात में नहीं दिए, they are not a free pass, but they are a reparative and compensatory mechanism. They are a repairing and compensatory mechanism for these people and they deserve it. Further, Justice Bhatt said this would open a Pandora's box and may lead to constitutional mischief. Means in case you give EWS reservation by excluding the SC, ST, OBCs, further constitutional mischiefs will start. Many more will ask for it. Let's go down. Now we'll just discuss certain constitutional articles dealing with the reservation. Article 15.4 and 16.4 we all are aware. They provide for reservation for SC, ST in government jobs and educational institutions. Article 16.4a in response to Indira Savni judgment, wherein reservation in promotion was rejected. Indira Savni judgment had said, even SC, ST cannot have a reservation in promotion. The Parliament got together, brought in the 77th Amendment. They endorsed reservation in promotion is permitted for SC, ST if not adequately represented. ये घुंडी डाल दी. If not adequately represented, they can be granted reservation in promotion. 85th Amendment of 2001 brought. You see, the Parliament was very proactive when it came to safeguarding the rights of the SC, ST. 85th Amendment provided for consequential seniority also in promotion. Article 16.4b, 81st Amendment 2001 further said that in case the SC, ST vacancies are unfulfilled in one particular year, they have to be carried forward to the next year, and they nullified the 50% cap for that particular year. Even if it breaks the 50% cap, the carry forward has to be done to the next year, so that the reservation doesn't go waste. So very strong protection of the SC, ST interests by the Parliament. Article 15.6 and 16.6. These were the latest additions into 2019. It provides for 103 amendment and 10% reservations for the economically weaker sections amongst the unreserved category. Now let's discuss certain important court judgments. Certain important court decisions. They'll help you out in your UPSC examination. 1951, the State of Madras versus Mrs. Champakam Dorairajan. The Supreme Court said, while Article 16 provides for reservation, there is no mention of the same in Article 15. The Parliament got together and brought in the first amendment and added Article 15.4 in the year 1951, and hereinafter the ST, SC reservation in education and jobs started formally. In 1973, the famous case Anand Bharti versus the state of Kerala. Herein the doctrine of basic structure of constitution came. The Honorable Supreme Court ruled parliamentary powers to amend constitution are not absolute. Parliament cannot amend the constitution at its whims and fancies. The parliamentary authority doesn't extend to damaging the basic structure of the constitution. Means the parliament has no authority to damage the basic structure of the constitution, and in case they try and damage the basic structure of the constitution, will declare it ultra vires. Now the 2006 M. Nagarajan versus Union of India. Look, the Nagarajan and one more case, general case, are about promotion reservation. Now in the Nagarajan case, the question before the Honorable Court was whether reservation is be permitted to the SC and ST in promotions or not. While upholding the validity of Article 16A, the Supreme Court ruled reservation in promotion to SC and ST is valid subject to a 3-point test. 3 gundiya dal di. What were the 3-point tests which were required to be followed? The SC and ST should be economically and educationally backward, accepted, should lack adequate representation in the government employment, and should not, the giving of reservation should not affect the administrative efficiency. Now these are very vague terms. The SC further said that if these 3 conditions are met, we allow reservation in promotion. The second clause, that it should lack adequate representation in the government employment, raises a question: how much is adequate? The mute question remained: how much is adequate? This required quantifiable data. So in a way, the Supreme Court said, in case quantifiable data is provided, we permit reservation in promotion, which became very difficult for the government. One more case came. In their 2018, another case of Jarnail Singh versus Lakshmi Narayan Gupta, 2018. The moot question before the Honorable Court was, can the government give reservation in promotion to SC, ST without giving quantifiable data? Earlier in the previous case we discussed, it was clear that quantifiable data was required in the Nagaraj case. But in Jarnail Singh case, the question discussed was, is there a requirement of the government giving quantifiable data? The SC reversed this previous decision. It said reservation in promotion doesn't require any quantifiable data for SC and ST. So they went against the Nagaraj decision. They said कोई जरूरत नहीं है quantifiable data की. The government need not give any numbers in the public domain, and thus the SC ST reservation became a discretion of the state governments. Further, the SC said in Jarnail Singh case that reservation at entry level is the right of the SC and ST. They can go to the court in case they are denied. But reservation is promotion is totally the discretion of the state. Different states, in case they want to give the reservation, they can give. In case they want to deny it, they can deny it. Further, the Honorable Court added and said that for reservation in promotion, the creamy layer criteria will apply. And rightly so. Son of an IAS officer who's a SC, ST, who's got all the things, the best of the education, should not be given at least reservation in promotion. They are given reservation in entry level, agreed. But promotion to the Honorable Court seemed flawed. So creamy layer criteria was imposed on the SC, ST too, as per the Jarnail Singh case. Now let's go further down. Certain common doubts and questions. Well, large number of students are confused as to who all comprise of SC. Dear students, the Hindus, since inception of the constitution, certain Dalits and Hindus are SCs. In 1956, the Dalit Sikhs were included in SCs. In 1993, the Buddhist Dalits were included in SC. However, there is no reservation amongst Muslims and Christians for SC. Next question. Who comprise the ST? Scheduled tribes, कौन है? Well, the scheduled tribe status is independent of religion and faith. It is religion neutral. Religion got nothing to do with the SC status. Any person of any religion living in a given geographical area and having qualifying as a tribe would get the ST status. Means it is applicable to people of all religions depending on the inaccessible and backward and difficult geographical areas. It is geography specific. Means as scheduled tribes exist in all religions, Hindus, Sikhs, Buddhists, Christians, Muslims, etc. Who are the OBCs? Let's see who are the OBCs. The other backward classes. Well, post implementation of the Mandal Commission, apart from Hindus, Buddhists, Sikhs, several Christians and Muslims also have found a place in the central and state OBC. So the OBC category has got Christians, Muslims and Buddhists, Sikhs and Hindus all backward classes. Large number of classes of Christians and Muslims are also part of the OBC. Now gentlemen, we are reaching the conclusion. Let's conclude. If you have to write an essay, conclusion will become important. The conclusion is, as of now, the social and educational and economic also backwardness have become a criteria for reservation. Economic has been included the latest in 2019. There have been 75 years of independence and 72 years of constitution, and still counting, the reservation continues. However, gentlemen, the reservation is not an end, it's a means. Reservation should be self-eliminating. It should end at some stage. And reservation should not develop into vested interests. We have seen vested interests being shown by a couple of castes and politicians also to propagate reservation. Meritocracy should not suffer. It be debated that creamy layer be introduced into the SC/ST reservation also, so that it could benefit the genuinely needy SC/ST and not sons and daughters of high-ranking bureaucrats and politicians. It's time to evaluate and generate a larger public debate to evaluate the benefits and demerits of the reservation. Reservation was initially aimed at promoting equality, however, it perpetuates inequality. It's perpetuating inequality. Our constitution had a design and wanted the reservation to be self-eliminating. The process of desensitization is taking place. The race to the bottom for reservation best be prevented. Founding fathers of the constitution never wanted to perpetuate reservation till eternity. Political reservation was to be reviewed every 10 years but perpetuated still. Note, gentlemen, 21st century is an age of knowledge, and merit alone should take India forward. A larger public debate needs to be generated for discussing the merits and demerits of reservation, and at some stage it has to be self-eliminating. Thank you and Jai Hind.